Hi, Judge. For Mr. Arnold, we also have a bond motion, and that one should only take a few minutes.
Yeah, just let me, I'll work through those. We'll move from the bond to the other things, and then, but just give me a minute.
Thank you, Judge.
Okay, thank you, madam. Okay, let's see if I can find Mr. Kendrick, where are you? Mr. Kendrick, if you are on the platform, please raise your hand, please. Mr. Kendrick.
Give me 1 second, Judge. You have several inmates that have to share booth. So
Yes,
he's
ma'am.
going to come in 5 North. Give me 1 second. He's going to come in the 5 North booth.
Okay, just hang tight. All right, thank you. Mr. App, my plan is to, since okay,
Judge,
yes, ma'am.
I'm sorry. Inmate Kendrick just entered 5 North booth whenever you're ready.
Mr. Kendrick, raise your hand, sir. All right. All right, Mr. Apt, I understand you have several motions. I'm just going to note them for purpose of the record. One, you have a motion to sever, an amended motion to sever. 2, you got a general demurrer, motion to strike, motion to dismiss, an amended general demurrer, motion to strike, motion to dismiss, a special demurrer, motion for additional time to file additional motions. That's very trendy, Mr. Apt. Amended motion for additional time to file amended motion or additional motions, consolidated motions, and a motion to strike. Is that correct?
That sounds very accurate. I try to be as trendy as possible.
All right, okay. I will group you with the folks that are that have filed severance motions. So if you could just bear with me. I do believe I'll have to hear your motion, your general and special demurrers. So let me go ahead and as soon as I've finished, I'll put you in line for me to do that. Okay.
Your Honor, we are here at the court's pleasure always.
Okay.
So.
All right. I just wanted to make sure that I've accounted for everything to begin with, and but I'll call you in just a minute. Okay.
Thank you.
All right. Thank you, sir.
Your Honor, I apologize. Mr. Steele has brought to my attention that we also have, just for business keeping, or keep things organized, my client needs to waive any potential conflict.
I was going to do that. That's one of the things I can probably take care of now. So, Mr. Stillwell.
Judge, if I can,
Yes.
he also needs to be arraigned on the new indictment.
Yeah, I'll go. Yeah, in fact, I've got that right here to do. So I'll go ahead and do that. arraignment last time, Mr. Geary, but,
I didn't have it down, Judge. I won't argue with the court.
let me just ask, counsel, Mr. App, the last time you were here, did you waive arraignment on the new indictment?
I cannot say, I know we've been arraigned once, but it might have been on the old indictment.
Let me just, in the abundance of caution, first, let me find Mr. Kendrick. Mr. Kendrick, raise your hand again. Ms. Amana, can you go ahead and unmute 506, please?
Your Honor, unfortunately, is unable to unmute at this time.
Yeah, we're still having technical difficulties, Mr. App. Mr. App, do you want to waive formal arraignment, and have the court enter a not guilty plea on behalf of your client, otherwise have at least 10 days to file motions from the receipt of discovery, sir, or any of these additional motions that you might want to, raise at that point in time that may be appropriate?
Thank you. Yes, Your Honor.
Okay, all right, granted. And again, we'll leave it for 9 January of 2023. And let me go, so that handles the new arraignment ending in 5/7/2, correct?
Correct, Your Honor.
Okay, all right. Let me go ahead and deal with the issue of the waiver involving Mr. Steele, okay? So can we come on up, please? But I am going to need Mr. Let's see.
Judge, you're asking for Shannon Stillwell.
I was, but I've got something more immediate. For Mr. Kendrick, is there any way that we can move him to maybe an adjacent booth that has audio? Because I'm going to need to talk to him, and we're having audio issues in N506.
Okay, give me 1 second.
Hold on, Mr. Kendrick. Hold on. They're gonna move you in just a minute, okay? Just give me a second, okay? All right. Okay, while we're waiting, let's see if do we have Mr. Stillwell with us now, ma'am?
No, Judge, he's not out yet. He's gonna share the 6 North booth.
Okay, all right, so we'll wait till he comes out, not a problem. Okay, all right.
Judge, could you have them to connect to 5 North booth 1 for me?
Ms. Amana?
Yes, Your Honor, let me go ahead and invite booth 1. Thank you.
All right.
able to connect to the audio in that one as well, Your Honor. Technical support is working on it. We now have, if you can return back to 5 N North 506. That one has now turned on.
Okay.
So you want him to move back to booth number 3?
Yes, ma'am.
Okay.
Thank you.
Thank you. All right, sir, and N506 booth 3, sir, what's your name?
Kendrick.
All right, this is Mr. Kendrick. Mr. Allen?
Yes, Your Honor.
Okay, all right, so I have Mr. Kendrick here, all right.
You are watching the Young Thug Gunner trial with Choke Move.
Do you have the statement, Mr. Allen, or the waiver? Do you have a copy of it?
I have a letter
A letter, yeah.
that I wrote to the court and to Mr. Steele in the state dated May 20th. of
Well,
this
let me, Mr. Allen, before I take your copy, let me just see if I have one here.
Yes, sir.
Okay.
I've got an extra copy of the court, Mr. Judge.
Oh, thank you, appreciate it. All right. All right, Mr. Kendrick, I'm gonna mark this as the next court exhibit in order, Ms. Weaver. And, Mr. Kendrick, I need to ask you a series of questions, due to, the fact that you were formerly represented by Mr. Steele, okay?
Okay.
I'm not going to ask you anything about the attorney-client privilege or any of the sum and substance of those conversations. This is more procedural. It's in terms of a waiver to make sure that that you're waiving any conflict about Mr. Steele's involvement in this particular matter. Okay.
Okay.
Do you remember a letter that Mr. Apt wrote and Mr. Steele on your behalf? It's dated on the 20th of May of 2022. Do you recall him talking to you about this particular waiver in the days prior to May the 20th?
I believe so, yes.
Okay, all right. I'm just gonna go through the letter that he wrote on your behalf to Mr. Steele, and then I'm going to ask you some questions, okay?
Okay.
All right, the letter reads, Dear Mr. Steele, I'm writing in regards to the above referenced case, and that case is, at that point in time, it was 22 SC 182273. That's been re-indicted in 22 SC 183572, in which the state has filed a motion to disqualify you from representing your client, Mr. Jeffrey Williams. On behalf of this law firm's client, Mr. DeMonte Kendrick, we hereby waive any and all potential actual conflicts of interest pursuant to the Georgia Rules of Professional Conduct, Rules 1.7, 1.9, and 3.7. Mr. Kendrick has no objection to your continued representation of Mr. Williams, and we would be happy to continue to make that representation in open court at any future hearing. Should you need anything else, please do not hesitate to contact me at any time. With kindest regards, I am sincerely, and has J-App's name, your lawyer. Are you familiar with that?
Yes, sir.
Okay, all right. I know that you and Mr. App talked about this before he authored this letter. Is that correct?
Yes, sir.
All right. Did Mr. App explain to you the types of potential conflicts that could come up when a lawyer who previously represents a defendant later represents another defendant in a case where they're co-defendants?
Yes, sir.
All right. Specifically, do you understand that the state could offer to dismiss the case against one co-defendant, reduce the charges, or agree to a lower punishment if that co-defendant would testify against the other? You understand that?
Yes.
You also understand that a witness might say something or evidence might come in helpful to one co-defendant but harmful to the other. You also understand that a lawyer may want to use a defense theory, witness, evidence, or argument that is helpful to the lawyer's current client but harmful to the lawyer's former client. You understand that? All right.
Yes, sir.
During closing argument, the lawyer may want to argue that the evidence against his current client is less than the evidence against the former client. You understand that?
Yes.
All right. If there's sentencing, the lawyer may want to argue that his current client is less culpable than his former client.
Yes, sir.
All right. And you also understand that the lawyer may have learned something from the former client that helps the current client but hurts the former client.
Yes.
All right. And did Mr. App go through examples with you about how these possible conflicts might come up in this case?
Yes, sir.
All right. And do you understand these potential conflicts?
Yes.
And are you still certain that no actual conflict exists and no actual conflict will ever exist?
Right.
All right. And you fully understand what Mr. App has explained to you?
Yes.
All right. Oh, I need to do something. You know what? Mr. Gary, I forgot to swear in. All right. Let me go ahead and do that. You're supposed to remind me. I asked you to do that. Mr.
You also asked me not to interrupt, Judge.
When do you ever listen to me? I mean, none of y'all do that. Hey, Mr. Kendrick, we need to kind of go through this again because I forgot to swear you in, okay? In my hesitancy, all right? Raise your right hand for me, sir. Do you solemnly swear or affirm the evidence you'll give me in the matter now and hearing shall be the truth, the whole truth, and nothing but the truth, so help you God, so affirm?
Yes.
All right. Do you swear that what you just told the court is true and accurate and complete?
Yes, sir.
Is on and is, do you want me to go through any of these again with you?
You were finished, right?
I'm sorry?
I said you were finished, right?
Well, pretty much, yeah, I was finished, yes.
Yeah.
But do you have any questions about about the waiver that Mr. App discussed with you or anything that I've added to discuss to make sure that you understand that waiver?
No, he pretty much went over everything with you.
Okay, all right. So do you give this waiver freely and voluntarily?
Yes.
Nobody's forced, threatened, or tricked you into entering this waiver?
No, sir.
And you're doing so because because you've talked with counsel and you believe it's in your best interest to enter this waiver. Is that correct?
Yes.
All right. Okay, Mr. App, anything else, sir?
Just for the record, Your Honor, in accordance with the Georgia Rules of Professional Conduct, Rule 1.7, there are 3 prongs to that rule before any defendant can waive a potential conflict. And I want to make sure that we're on the record that I've met those 3 prongs prior to today. The first would be to review the material risks in writing and give reasonable alternatives to the client. And I've done that. The second would be to give the client the opportunity to consult with independent counsel. And we've done that. And the third would be to meet and discuss the options and issues with my client. And we've done that as well. And as a result, as what you've just heard on oath from Mr. Kendrick, is that he is making a knowing, intelligent, and voluntary waiver of any kind of potential conflict of interest. Thank you.
All right. Mr. Gear, Ms. Rosenwasser, is that sufficient, madam or sir?
Yes, Your Honor, we feel that would be sufficient to waive the conflict with Mr. Steele. Our understanding is the only remaining defendant that hasn't orally waived as well as Mr. Stillwell.
Okay, and I think that we will have him in just a second, but we'll see. Okay, all right. Okay, Mr. App, just give me a second and we'll cover the rest of it, okay, in just a minute, all right? Or the ones I think I can cover today, all right?
Thank you, Your Honor.
Okay. Yes, sir. Anything else?
Well, just when you're ready to hear whatever motions you want from us, Your Honor, there are, I have 2 co-counsel and we've sort of divvied up the work, so.
Okay, all right.
Katie Hingerty and Mr. Doug Weinstein, who are here.
Okay, as soon as I can get to it, just give me a minute.
On the screen. S and Lee.
Mr. Eppinger, can you hear me, sir?
Yes, sir.
All right, give me 1 second. Yeah, you probably will. Can you interrupt him just a second? See if you can get Sim up to come out. Yeah, Mr. Siminoff, I'm sorry to interrupt you. We have Mr. Eppinger here with us at this point in time, position number 1. I was just going to ask him some questions about representation. Mr. Eppinger, good morning, sir. Sir, do you have an attorney?
No.
Would you like the court to go ahead and appoint you an attorney for this case?
Yes, sir.
All right. I'm going to have Mr. Siminoff, who's with the Public Defender's Office, talk with you in just a minute and qualify you to see if you can qualify for the services of the public defender or conflict defender. And we'll go ahead and let him do that this morning.
I'm sorry, I actually have information on Mr. Eppinger. His case was already submitted for C3 counsel on August 19th from our office, and it was approved and forwarded to the state office. So if he doesn't have a lawyer at this point, I believe the state office is still working on securing representation for him, but our office is part in that process already.
So you've already started that process?
We've already submitted the form. They've been approved by my supervisor and forwarded to the state office, Judge.
Okay. Mr. Chamberlain, since he's in GDC custody, can we put him back on for the 5th of October and see if that counsel will join us at that point, by that time? Okay, all right. Mr. Epinger, I'm going to go ahead and put you on for the 5th of October. So it looks like the quest to have representation for you is already started. So somebody should be reaching out to you very soon to talk with you about representation, okay?
Yes, sir.
But I am going to go ahead and put you back on for the 5th of October, okay?
Yes, sir.
All right. Unless you have any questions, sir, you're welcome to remain, or I can go ahead and release you, okay?
I'm good.
Say again?
I said I'm good. I'll leave.
Okay, all right. Thank you, sir. Okay, all right. All right, thank you, Mr. Simmons. I appreciate it. All right, is Mr. Stillwell on the platform?
Judge, he's not out yet. Inmates still will have some special conditions to where the deputies haven't been able to escort him out to the booth yet. So they're asking for a little bit more time
Oh, yes,
to
ma'am.
get him to the booth.
That's perfectly fine. Just let us know whenever he is ready.
Yes, sir. Thank
Okay,
you.
thank you, madam.
Mr. Adams and Mr. Adams, Mr. Seda put in the Zoom chat that when counselor at the defense table, we can hear everything you were saying, even when you whisper. That mic is hot.
Thank you, Steve.
Thanks, Dave.
But he's happy to have you keep talking. So probably for obvious reasons, but okay. All right. Let's see what else we have here I can take care of.
You're not saying right. I'm sorry.
Who is that? Yeah. I don't believe that. Okay, that's one. All right. While we're waiting, let me see if I can take up just a couple other additional matters. I know we had Mr. Kitchens on the platform. I've seen him earlier.
Mr. Simmons, yes, is on before Judge Lethbridge. and 8H picking the jury. So it said when you're ready for her.
I'm ready.
Just
Yeah, I just saw him just a second ago.
so you wasn't quite ready.
Mr. Williams, Mr. Steele, where are you? Mr. Steele, I can take up your matter with Mr. Williams. Let me see if I can find him on the platform. Just give me a second. I see him. I'm moving over. All right. Okay, yeah. All right, Mr. Steele, I can go ahead and do, and Mr. Geary, I can take up the matter involving the motion regarding the temporary order restricting disclosure of discovery material pursuant to 17-16-4 Delta and motion for complete discovery. The other things that I'll note that have been filed, I'll note them just for the record. I'm not going to take them down because they're more so dealt with closer to trial. One is motion to limit disclosure of witnesses' location. I think that's fairly contained within this motion for complete discovery. Motion to restrict a juror's identity. Motion addressing juror note-taking and consideration of evidence during trial, and motion addressing juror selection and strikes. So for the restriction of juror identity, note-taking, and the selection and strikes, I'll defer those until a little bit closer. I believe that the motion to limit disclosure of witnesses' location is fairly contained, as I mentioned earlier, within the motion to restrict. Let me ask counsel for the state and counsel for the defendants, have you all had any discussions about the limitation of discovery? Or are there agreements as to what you might agree to?
Your Honor, we have not, because we wanted to make sure that we did that in the public forum. I did want to make one more comment about the jury motions when Your Honor would permit me to do so. If I may do that now or later.
Well, complete your thought.
As for the jury motions, the only thing that we would ask the court to rule on right now is our request for a jury questionnaire. Because basically right now we're, 4 to 5 months out from trial. If the court is inclined to grant our request for a jury questionnaire, that's obviously going to take some time to prepare. So we would ask that the court be inclined to consider our request for the jury questionnaire.
I'm probably going to do one anyway, so yes, you all can start that process at this point in time. Yes.
Thank you, Your Honor. As for the discovery motions, we have not discussed this.
Your Honor, excuse me, may I speak just for a moment? We have also filed, I know Mr. Steele is going to argue this as part of his motions, but Mr. Kitchens has also filed a response dealing with the state's motion to restrict discovery. Do you want us to join in with Mr. Steele, or do you want us to?
Yes, you can join in with that at this point. I believe Mr. Samuels is in the courtroom as well now, so. Okay, but yes, sir.
All right, and our response, so the court knows, was filed on August 22nd, and should be on the court file.
Okay, all right.
Thank
Yes, that was Mr. Seda. Folks, I'm going to say a couple things for purpose of record. Because of Zoom, you need to identify yourselves when you first start talking, okay? Because Ms. Weaver, my court reporter, my official court reporter, doesn't know who you are necessarily, but so if you could be so kind, just to, when you first start talking, identify yourselves for purpose of record. Then we can go ahead and make the best record we can. The other thing is, speaking of records and citations to records in your motion, there are a number of you that have already started to utilize the either tape or Zoom or any other types of recordation. I'll just remind you politely, that is not the official record. The official record is the one that is set forth by Ms. Weaver, my official court reporter. So if I'm not going to, if you file a motion and it has some other recordation, other, timestamps or anything like that, they're of little consequence to me unless there's an issue as to the difference between the official record and some other thing that has been possibly presented like an error. And then there's a way that you go about fixing those particular issues that's set out by statute. So I just want to remind everybody that's because we've already started to get motions with other types of alternative transcription or other sources. I'm just going to remind you again, they're not the official record of the court, and barring some other authorization, I won't consider them. So, okay. Mr. Sandel, I know you gotta run, right?
No. I'm here for you, sir.
Um,
I just haven't talked to you.
Say again?
I just haven't talked to you quickly. You need it now?
Yeah, I was gonna take up his matter, so.
Ms. Rosenwasser's gonna handle this now.
Say again?
Ms. Rosenwasser's gonna handle this motion, yes?
Yes, you may, sir. Yeah, absolutely.
But it's tough. You need to, the older motion.
Your Honor, this is Steve Sadow. So the court knows, while Don is present, I'm going to be doing the arguing on the motion.
Hold up.
Hold up, Mr. Sada, I'm talking to my deputy. Just hold on one second, okay?
No problem, sir.
Thank you. Mr. Sharp, the deputies would like to talk with you just for a minute, okay? Yeah, they'll talk with you for a minute, all right?